Good morning, students. Today I'm talking about the topic modes of winding up of business. And this is unit number 5 of your syllabus. This is also a very important topic of company law. That is a procedure involved in respect of the winding up of the company, or you can say, in other words, dissolution of the company. That is a final result of the winding up of the company. There are various modes of winding up of the company. As per the Companies Act 1956, that is a previous company law, or Companies Act 2013, that is the latest amendment in the Companies Act in the 2013, that is the new Company Act and Companies Act 2013, provided for two modes of winding up. One is winding up by the court, another is voluntary winding up. So that is about the modes, or you can say methods of winding up the company, closing the business of the company, and uh, discontinue the business operations of the company. And what discontinuing your operation, we have to follow the official procedures and provisions of the compliances of the Companies Act as applicable for the private limited companies, whether in respect of private limited companies or public limited companies. There are certain procedures involved in respect of private limited companies as per the Companies Act 1956 as applicable for the winding procedures, and Companies Act 2013, that is the latest amendment in the Companies Act. So winding up meaning is that you wish to close down your business, and for that, because business starts by legal formalities and by legal formalities. So winding up is not an easy process. You have to go through so many legal formalities in respect of relation in connection to the winding up of the company, and closing of business concerns and business enterprise is a complicated procedure is involved because so many legal formalities involved in respect of the incorporation of the company, and you are doing too many transactions during the after the incorporation, after the commencement of the business of the company, engaging so many transactions with third parties, and may make payments, may not make payments on time, and there's a debtors are there with the company. So we have to make their dues, payment of dues on at the time of dissolution of the company and of the company, so that you can close your books of accounts for the purposes of winding up. Books of account has to be closed. All the assets has been realized, liabilities have been paid off, so that the we can comply with the procedures of the Companies Act in respect of the finding of procedures. So winding up is the procedure, and the I already explained you winding up is the procedure, and the dissolution is the end result of the procedure. So after completion of all the legal formalities, the company is going to dissolve. A company is going to end. So this is the end of life of the company. A company is an artificial legal person. A company is not like a natural person. Company has the artificial characteristics. Company can present in the court of law, have existed in the court of law, by in the form of documentary evidences, in the form of common seal of the company, and the directors of the company, they represent the company on behalf of the company. So company may be wound up. There are so many methods of winding up of the company, and the company may be wound up in any of the following two ways: compulsory winding up as per section 272 of the Companies Act 2013, that is the compulsory winding up as per the section 272, and liquidation under Insolvency and Bankruptcy Code 2016, that leads to the winding up of the company, liquidation under Insolvency and Bankruptcy Code if the organization or your business concern enterprise declared insolvent or bankrupt In that case, what procedures to be followed for the purposes of liquidation, um, or closing of the books of accounts of the company, or how to procedures followed in respect of the winding up of the company in case of liquidation because of the case of insolvency and due to insolvency and due to bankruptcy. As per because this code is applicable for the purposes of winding up of the company in if the organization is declared insolvent in the court of law or bankrupt in the court of law because of non-payment dues on time. After so many reminders to the company, still come not pay their dues on time and interest on time, as per this thing. And this code is applicable. This code is applicable to the company. Insolvency bankruptcy code 2016 is applicable to the company for the purposes of winding up of the company. So a compulsory winding up by a company by the order of the tribunal is known as compulsory winding up. So when the national company tribunal means, I already explained you in the previous sessions and classes. Tribunal means national company law tribunal or national company law appellate tribunal. So compulsory winding up of a company by an order of the tribunal uh, is known as, that is a simple basic definition of a compulsory winding up. When winding up of a company is by an order of the tribunal is known as a compulsory winding up. That is a simple definition of the winding up by the order of the tribunal. That is compulsory winding up as per Companies Act 2013. Then there are various grounds of winding up of a company, or you can say, in other words, dissolution of the company. There's various grounds, or you can say various modes of winding up. So, as per Section 271 of the Companies Act, tribunal may order for the winding up of the company on petition submitted to it on any of the following grounds. So, grounds are there on which basis tribunal may order for the winding up of the company. If any petition means an application is filed, an appeal is filed by any shareholder of the company or any member of the company to the tribunal, that tribunal must allow, may issue an order for the winding up of the company. So if in the case of petition is filed by suppose thousands of shareholders, they filed a petition before the tribunal to may issue an order for the winding up the company. That is also called a dissolution. When company is going to wind up, that then company dissolved, cannot continue its business afterwards, and all the members are ceases to be a member of the company. All the directors are ceases to be directors of the company. All the founder members are ceases to be founder members, ceases to be members of the company, and the company ceases to exist after when it is declared by the tribunal that is wound up and dissolved after fulfilling all the legal formalities in respect of the dissolution of the company. So tribunal may order for the winding up of the company. So number one point in this, passing of a special resolution for winding up. So when a company has, by passing a special resolution, resolved to be wound up by the tribunal, winding up by order may be made by the tribunal, meaning is that for the winding up of the company, you have to pass a special resolution for the winding up. Otherwise, you cannot wind up, because the company starts with legal formalities, and by legal formalities, the consent of all the members of the company, or at least 70% of the majority with the resolution, with the proposal for the winding of the company during the meetings of the company, with the shareholders meetings of the company. So without passing resolution, the wind-up procedure cannot be started, cannot be initiated by the company. So company has to initiate the procedure for the winding up by passing a special resolution to this effect in the general meetings of the company. And when a company has, by passing a special resolution, resolved to be wound up by the tribunal, uh, then winding up order may be made by the tribunal. If it is passed in the meetings of the shareholders, in that case, the tribunal may allow the company to start the procedure for the purposes of winding up of the company. Uh, so, by passing a special resolution for the winding up. So resolution may be passed for any cause whatever. The tribunal may not order for the winding up if it finds it is to be opposed to public interest or the interest of the company as a whole. So passing a resolution for the winding up, and when a company has for this company has to pass a resolution in the general meetings. Then a tribunal will allow you to start your legal procedures in respect of the finding about the company, because company cannot speak. Company is an artificial person. So without the consent of the members, without the consent of the company or as well, and you start the procedures to wind up the company with your own self, then uh, it is not acceptable, and it is not at the discretion of the court, or at the court it is declared cancelled. It is not acceptable. Rewinding procedures, but we cannot rewind without the consent of other members of the company who have made their capital contribution to the company and the form of shares into the company. So resolution may be passed for any cause whatever. Tribunal may not order for the winding up of the company. It is find it opposed to public interest or the interest of the company as a whole. So meaning is that for any for incorporation of the company, for dissolution of the company, for winding up the company, the consent is very important. The consent of all the members present in the meeting, the consent towards that proposal in the meeting is very important for the purposes of winding up of the company. Uh, then tribunal may allow the uh, for to start the initiate the procedures involved in regard to the winding up of the company, and tribunal may not order for the winding up if it finds it to be opposed to public interest or the interest of the company as a whole. Because company is an artificial legal person. Company cannot speak in the court of law like a natural person. The directors of the company, they are representative of the company. They are act as an agent of the company. So they represent company in the court of law towards third parties for making contracts, signing contracts with suppliers of the company, vendors of the company, lenders of the company. So if tribunal thinks that it is not good for the company to wind up, and it is not in the interest of the company to wind up as a whole, because being an artificial legal person uh, does not have a physical existence like a natural person. Um, so sometimes directors act for their own interest and disregard to the interest of the company and disregard to the larger interest of the shareholders of the company. And in that case, if any tribunal thinks that it is not good for the company to wind up at this early stage of incorporation and after just commencement, when the company is going to wind up, because of the directors of the company who thinks that it is good, it is better for the company, fit for the company to wind up at this stage, but it is not good for the general interest and for public interest and interest of the company as a whole. In that case, the we can issue the board can issue an order, stop the issue an order to stop the process involved in respect of the winding up of the pub. Then continuation of the grounds of winding up. If the company has acted against the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, uh, in that case, the if against the interest, court may issue an order for the uh, winding of the company if the company has acted against the interest of the sovereignty and integrity of India and security of the state, trade relations with foreign states, public order, decency or morality. These are the grounds of winding up, where court can issue an order to the company for the winding up of the company, to start the process of winding up of the company. The court found that the company has acted against the interest of the sovereignty, against the interest of the India, security of the state of India, with friendly relations with foreign states, or public order, decency, or morality grounds. On these grounds, court can issue an order. The tribunal can issue an earlier it is company law board, now it is tribunal. Earlier it is CLB. CLB is company law board, now it is tribunal. Tribunal means National Company Law Tribunal. So on these particular grounds, the National Company Law Tribunal issue an order uh, for the purpose of winding up of the company. And if an application made by the registrar or any other person authorized by the central government by notification under this act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, and the company was formed for fraudulent and unlawful purpose, and the person concerned. The meaning is that if on an application made by a registrar or any other person, authorized persons by the central government under this act, tribunal is of the opinion that the affairs of the company, if registrar issued an application, made an application to the tribunal that, or any person authorized by central government made an application to the person, in case of government company, when all central government and state government share capital contribution is there, at least 50% of the shares must be held by the central government, state government, or respective governments. And the tribunal is of the opinion that affairs of the company have been conducted in a fraudulent manner. The objective is to commit fraud, is to commit manipulation in accounts, books of accounts, misappropriation in books of accounts, purging of accounts. That is objective. If a registrar it find it as and made an application to the tribunal or any other person or tribal central government, that person made an application to tribunal, and if tribunal find it that it is that company have been conducting their business in a fraudulent manner, fraud element is there, or purging of account is there, misappropriation, manipulation is there, and when a company was formed for fraudulent and unlawful purpose, or the person concerned in the formation or management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and it is that is proper that the company may be formed of. So, on these ground, the tribunal may order for the winding up of the company when the company conducting their business activities in a fraudulent manner. The company objective is to commit fraud. The company was formed, incorporated for committing fraud and for illegal purposes, unlawful purposes, and the person concerned there are in the formation management of its affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and that is a proper that the company be wanted. Next point in this, if the company has made and default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years. Uh, Meaning is of this line is that if there is any default on the part of the company on filing of the statements, financial statements and returns with the registrar of the company, that is required for the immediately preceding 5 years, consecutive years. In that case, the tribunal may order for the winding up of the company. Because company not submitting its records from the last 5 consecutive years, not filing their returns for the last 5 consecutive years, in that on that particular ground, the tribunal has a power to issue an order for the discontinuation of business of the company and winding up of the business of the company. uh, on this particular ground of not filing of the returns and returns with the ROC of the company. And this is a non-compliance of the Companies Act. That is a non-compliance with the Companies Act or not filing of the returns, financial statement, profit and loss account, trading account, balance sheet, and all, cash flow statement, one flow statement, as required for the as per the accounting standards and as per the double entry system is there. So proper maintenance of account is there. Notice prepared, not submitted, not filed with the ROC for the last 5 years. In that case, the tribunal may order for the winding up of the company. And the next round is just and equitable. The tribunal may order for the winding up of the company if it thinks that there are just and equitable grounds for doing so. It is better for the company. It is equitable. It is fair for the company to be wound up. Voting it is just and equitable grounds for the company to be wound up. Tribunal has a very large discretionary power in this case and determine just and equitable grounds may include any of the grounds for the winding up of the company. And this power has been given to the tribunal to safeguard the interest of the minority shareholders and weaker group of members. So when the tribunal thinks that it is just and equitable for the company to be wound up, in that case, tribunal may issue an order for the winding up of the company at the by using their discretionary power in this case that is given to the tribunal uh, as per the act. So it may include any of the grounds for winding up the company. This power has been given to tribunal to safeguard the interest of the minority and the weaker group of members. Then come to the grounds of winding up. So tribunal here means I've already explained to you. Tribunal means National Company Law Tribunal. Before passing such an order, order means order for winding of the company, will take into account, will take into consideration the interest of the stakeholders of the company, and that consists of shareholders of the company, creditors of the company, employees of the company, and the general public at large should be taken into consideration before issuing an order, before passing an order for the winding up of the company. So, tribunal may also refuse to grant an order for the compulsory winding up of the company. This is a power available to tribunal to refuse to grant an order in the case of compulsory winding up of a company, and if it is the opinion that some other remedies available to the petitioner to redress his grievances and the demand for the winding up of the company is unreasonable. So here are the few examples of just and equitable grounds on the basis of which the tribunal may order for the winding up of the company are given. So sometimes when the court thinks it is just an equitable grounds, it is good for the company to wind up, and for that case, the tribunal may issue an order to the company to start the procedures of winding up, legal formalities in relation to winding up the company. Sometimes there is a note in there. Sometimes tribunal have a right to have a power as per the Act, Companies Act 2013 of Ministry of Corporate Affairs, Government of India. Tribunal may refuse to grant an order. Sometimes tribunal have a right to refuse grant an order for the compulsory winding up of the company. If it is of the opinion of the tribunal that remedies available to the petitioner to redress his grievances and the demand for winding up the company is unreasonable demand. This should be noted down. This line to be clear to all of you that the demand for the winding up of the company is unreasonable demand. That is not genuine demand. That is unreasonable demand. So demand is unreasonable, which is not genuine, not fair, not true, not just and equitable. In that case, the court may refuse, may deny to grant order for the compulsory winding up of the company. So, few of the examples of just executable grounds on the basis of which tribunal may order for the winding of the companies are given, and these grounds are grounds of winding up. Number one point in this operation of minority, and in cases where those who control the company abuse their power to such an extent that it seriously prejudices the interest of minority shareholders, the tribunal may order, I'm just reading out this line, a tribunal may order for the winding up of the company when a tribunal thinks that, believes that there's and have proof of documentary evidences that there's an operation of minority, have proofs of the minutes of the meetings and meetings validation interest meeting, proofs of the minutes of the meeting that there's a operation, there's a case of operation of minority. In such cases, so they need to find out who controls the company, and where those who control the company abuse their power to such an extent that it seriously prejudices to the interest of the minority shareholder. There's a need to find out who are involved in operation of minority, the person concerned, the officers concerned who are involved in the that particular type of case of operation involving engaging minority shareholders of the company. And it is a serious matter, it is a matter of serious concern for the tribunal that the company officers and company directors of the company or the members of the company, they are responsible. They are responsible for the oppression of minority interest in the general meetings of the shareholders of the company. And if they thinks that it is have reasonable proof of that, documentary evidence of that of oppression of minority, tribunal may order for the in that ground on that particular ground. Tribunal may order for the winding up of the company, and tribunal will issue such an order only when it is impossible for the business of the company to be carried on for the benefits of the company as a whole, owing to the way in which voting power is held and used. So tribunal may issue an order only when it is impossible for the business of the company to be carried on. So tribunal in that condition, in that particular ground, tribunal have power to issue an order for the winding up of the company, for the benefits of the company as a whole. Uh, that power is rests with the tribunal to order when it is impossible for the business of the company to be carried on. In that case, that is a genuine reason expressions are there. For the benefit of the company, it is better to close it down, its business now. So, in that particular case, when tribunal thinks that it is impossible for the company to continue anymore because company running into losses for the last 5 years, not in a condition to pay off its debts on time and its dues on time. In that case, it is better for the company to close and discontinue its operations. The next point in this deadlock in management. This is point number two. Deadlock in management. Where there is a complete deadlock in the management of the company. The company may be ordered to the point of, but mere incompatibility of good relations between the rival factions of the directorate. The majority group and minority group will not be sufficient for ordering mandate. This is a case when there is a complete deadlock in the management of the company. Complete deadlock. So company may be ordered to wind up by the authority tribunal, but mere incompatibility of good relation between the rival firms functions of the directorate and majority group will not be sufficient for ordering the winding up. Meaning is that relationship is good or bad. It does not is not a sufficient case ground for ordering the winding of the company by the tribunal. But this is a ground. Deadlock in management is a ground of winding up when there is a complete shutdown, complete setback in the management of the company. In that case, tribunal have power to issue an order for the winding up of the company. But the case in this that incompatibility issue between the rival and functions of the directorate, like majority group and minority group, that does not is not a sufficient cause for issuing order for the winding up of the company. But setback in management is a case. Setback in management is a case for winding up of the company when management not able to function it properly as required for the management to function as director of the company, as a member of the company, and is a complete setback, complete total setback in the functions of the management of the company. They're not doing their business on time. They're not doing their activities or functions on as required to do as a director of the company, as a member of the company, as a manager of the company, as a managing director of the company, full-time director of the company. They're not doing their duties and responsibilities as required to do as per the Companies Act 2013. In that case, there is a complete shutdown, complete deadlock in the management of the company. In that particular condition, the tribunal may order for the winding up of the company. Then come to the grounds of winding up. Again, continuation of the grounds of winding up. Loss of substratum, where the objects for which a company was constituted have either failed or become substantially impossible to be carried out. Substantum of the company is lost. Uh, you should know the meaning of these lines. Where the objects of the for which a company was constituted, company was formed, company was incorporated as per the Companies Act 2013. Object clause is there in the MOU of the company. Have either failed to achieve the objectives of the company or substantially impossible to carry out the fulfill the objectives of the company, and it is the very purpose of incorporation, very purpose of formation of the company is lost. In that case, court may order, the tribunal may order to issue for the winding up of the company. So when the temporary difficulty it does not knock out the company objectives, purposes may not be permitted to become a ground for liquidation. That is not the case. And this is a note in that temporary difficulty arises during the course of business. That is not a sufficient ground for the purpose of liquidation or winding up of the company, because temporary difficulties or complications or problems or risk elements are part of business activities. So temporary difficulties does not knock out company objectives and purposes and may not be permitted to become ground for liquidations. So that is a case, that is a note in this temporary difficulty, which does not knock out the company objectives and purposes of the company, and that is not a valid ground, sufficient ground to order the issue for the winding up of the company. So loss of substantum is a question of fact depending upon the circumstances of the case. The loss of substantum is a question of fact depending upon the circumstances of the case, when for the very objective, for the very purpose for which the company was incorporated, company was formed, and company disregard to the objective, disregard to their object clause of the memorandum decision of the company. In that case, on this ground, when company lost its objectives, not able to achieve its objectives, as mentioned in the MOU of the company, in that case, the tribunal may order for the uh, liquidation or winding up of the company. So this is a loss of substantum. That is a question of fact depending upon the circumstances of the case. Then come to the grounds, again continuation of the grounds of winding up. Default in filing with the registrar, its financial statements, etc. That is also a non-compliance of the provisions of the Companies Act in respect of the default in filing of the important documents with the registrar of companies and its financial statements with the registrar of companies and reports with the registrars of companies. Registered companies can also initiate binding proceedings against the company if it fails to file its financial statements and annual returns for a consecutive period of 3 years. Uh, and the famous case law in the case is Shiv Shankar Trading Company Limited. The court held that a company that has not filed its financial statements or annual returns for 3 consecutive financial years can be wound up on the grounds of public interest. That is a case law in this. The court, and the result of the case is that the court held that the company has not filed its financial statements and returns for 3 consecutive years and can be wound up on the grounds of public interest. So this section. This section is about the non-compliance of the Companies Act 2013 in respect of filing of your annual statement and annual returns with the registrar of companies. One copy has to be submitted to the registrar of companies after the annual general meetings of the company. All the account has to be prepared and the annual report of the company has to be submitted to the ROC of the company. The famous case in this, Shiv Shankar Trading Company Limited, is the case law. The court held that a company that has not filed its financial statements or annual returns for 3 years consecutively, court may issue that is a valid ground for winding up of the company, and court may use this ground for the purposes of issuing orders for the winding up of the company. Uh, when in the case of sovereignty and integrity of India, the government can file a petition for winding up of a company on grounds of national security, on these particular grounds of national security, sovereignty, or integrity. In that case, the petition means application has to be filed by the government to the tribunal to order the winding up of the company on the grounds of national security, number one, number two, sovereignty, or number third, integrity. And there's a case law in this. For instance, Union of India versus R.C. Chen. And in this particular case, two parties involved. One is Union of India, another is R.C. Chen. And the court held that the government could intervene and seek the winding up of the company if was found to be acting against the national interest. So, winding up on an application made by a registrar when affairs of the company conducted in fraudulent manner. In that case, also the tribunal may order for the winding up of the company. So, when court thinks and they thinks that it is good for the company to intervene in the activities and seeking for the winding of the company, when they found that the company functioned against the national interest of India or of the India or of the country where that particular business is situated located. So when company is working against the national interest or against the common interest of general public, in that case the court may issue for the winding up of the company. So winding up on an application with a registrar when affairs of the company are conducted in a fraudulent manner. So in that particular case, in that particular ground, the court, the tribunal may order for the winding up of a company. So the ROC of the company, that is registrar of companies, can also initiate winding up proceedings if it is found that the affairs of the company are being conducted in a fraudulent manner. So, in the case, there is a famous case law in this, that is Messrs. Hindustan Gum and Chemicals Limited versus State of Rajasthan and others. The court held that the registrar of companies had the power to seek winding up of the company, and if there was fraud or serious irregularity in the company affairs, in that case, the court may order for the winding up of the company if the court found it that the company engaged in serious irregularity on their accounts and fraud element is there. So in that case, the ROC had the power to seek uh, for the funding of the company on these grounds of irregularity in the conduct of the business of the company. The two parties involved in this case, one is Messrs. Hindustan Gum and Chemicals Limited, and another is State of Rajasthan and ORS. Two parties involved in this particular case. So, in the case of Severity Integrative India, and if you're seeing that some fraudulent activities happen inside the company, the directors of the company, they are engaged in insider trading, they are engaged in money laundering, and cheat element is there, fraud element is there on the part of the directors of the company. They are engaged in fraudulent activities, they are engaged in fudging of accounts, mismanipulation of books of accounts, misappropriation of books of accounts. In that case, the person, court may order for the winding up of the company. Then winding up by court, winding up by the tribunal, also known as compulsory winding up, and it is the process of dissolving a company by order of the National Company Law Tribunal, that is NCLT. And this process initiated when the company is unable to pay its debt on time, interest on time, and when it is just in equitable grounds, the tribunal may order for the winding up of a company or dissolution of the company. When it thinks that it is good for the company to officially end their business activities on these particular grounds of when company is not able to pay their dues on time, not able to pay their debts, whether it is borrowed capital or loans and advances from banks or financial institutions or creditors of the company. In that case, the court have power to issue an order for the winding up of the company as per Companies Act 2013. Then as per section 271 of the Companies Act 2013 provides for the circumstances or conditions under which a company may be wound up by the tribunal, and these include the following conditions and circumstances in which the company can be wound up, may be wound up by the order of the tribunal. Tribunal means National Company Law Tribunal. Number one point in this, if the company has by special resolution resolved that it will be wound up by the tribunal. So by special resolution, company can be wound up by the order of the tribunal for the purposes of winding up of the company by passing a special resolution to that effect in the meetings of the company. Then point number two, if default is made in delivering the statutory report to the registrar or in holding statutory meetings of the company, in that case, court have power to issue an order for the winding up of the company. If default is made in delivering the statutory reports to the registrar of the company or in holding statutory meetings of the company, in that case, court may order for the winding up of the company. If the company does not commence its business within a year from its incorporation, suspend business for a whole year. I've already explained this point in the previous classroom. Again, I'm repeating this line in this particular section. If the company does not commence its business within a year uh, after obtaining the certificate of commencement of business from the registrar of companies, then from its incorporation and suspend its business for a whole year, completely whole year, not doing any business activities for the whole year, um, after obtaining certificate of incorporation in the case of private company, after obtaining certificate of commencement in the case of public limited company, and does not commence at business, does not initiate started business for a whole 1 year after its incorporation or commencement. In that case, the court may order for the winding up of the company as per section 271 of the Companies Act 2013. Next point is if the company is unable to pay its debts, in that case, a court may order for the dissolution, may order for the winding up of the company. Then, if the tribunal is of the opinion that it is just equitable that the company should be wound up, in that case, the company has to initiate the process of winding up of the company when the court orders the company to start the procedures of winding up on the grounds of just and equitable. When court thinks that it's good for the company to be wound up, then in that case, court may issue the order, may permit the company to start the procedures in respect of formalities in respect of winding up of the company. Then there is an Insolvency and Bankruptcy Code 2016 that is also specify the concept of when the tribunal or court issue the orders for the winding up of the company. Received the assent of the President of India on 28 May 2016. The court aims to consolidate and amend the laws relating to insolvency resolutions of companies and limited liability entities, partnership and individuals which are contained in various enactments into a single legislation. So, Insolvency and Bankruptcy Code 2016 received the consent of the President of India. The assent is there of President of India on 28 May 2016, and this code aims to consolidate and amend the laws relating to insolvency resolutions of companies and limited liability entities, partnership in the case of partnership, that is the forms of business ownership, partnership, and individuals which are contained in various enactments into a single legislation. The main focus of this legislation is that providing selections and resolutions in a time-bound manner for maximizations of value of data assets. So the main focus of this legislation, that is Insolvency and Bankruptcy Code 2016, is to provide resolutions in a time-bound manner for maximizations of value of debtors' assets. So the court has put an overarching framework to aid SIC companies to either wind up their business activities or engineer and develop plans to start a new plan for rehabilitation, restart, reconstruction for company, and for the investors to exit from the company because of the insolvency or bankruptcy declared by the bank, declared by the court of law because of non-payment of dues of the company. So the code is the law. Insolvency Bankruptcy Code is the law enacted in the year 2016. Ensures that when a company declares insolvency or bankrupt by the court of law, in that case, the court may issue an order for the winding up of the company in the following cases of again to just for the good for the company. It is good for the company. Company is not in a condition to continue anymore because this particular ground. It is better for the company to again to restart with new hopes and new plans. Again to restart these investors to exist from the company, and the time given to the investors to exit from the company which is declared insolvent or bankrupt by the court of law, and to give aid to sick companies to either wind up because they are not in a condition to continue. They are declared as sick entities, sick companies as per the Companies Act 2013. The court has also empowered the operational creditors, workmen, suppliers, etc., to initiate the insolvency resolution process if default occurs. The code Code means Insolvency and Bankruptcy Code 2016 contains provisions for insolvency resolutions process as well as liquidations of companies. It is also provided voluntary liquidations of the company with passing of the code. So in the case of voluntary winding up of the companies and the companies of 2013, that has been removed. The concept of voluntary winding up of companies and the companies of 2013 has been removed. Consequently, Section 304 to 323, two of the grounds for winding up by the tribunal due to inability to pay debts and winding up under chapter this has been omitted. The Insolvency and Bankruptcy Board of India has notified Insolvency and Bankruptcy Board of India a voluntary liquidation process regulation 2017 effective from the year 1st April 2017. This is a code contains a provisions in respect of the insolvency resolution process has to be passed in the meetings of the company. Uh, for the purpose liquidations of the company, and it's right for the voluntary liquidations of the company passing out the code. But the concept of voluntary winding up the Companies Act has been removed as it is particular sections of the Act deleted. And again, the revival, rehabilitations of the sick companies has been omitted likewise. And Section 253 269 of the Act have been deleted. Two of the grounds for winding up are due to inability to pay debts, and second is winding up under chapter this has been omitted. So the Insolvency Bankruptcy Code Board of India should be notified, has been notified Insolvency Bankruptcy Board of India Regulation 2017 effective from 1st April 2017. To point number one in this, it is important to note that winding up does not necessarily mean that the company has failed or is incapable of running a profitable business. In some cases, it may be the most practical solution for resolving issues that cannot be resolved through other means. In that case, the tribunal may order for the winding up of the company. Um, so winding up does not mean that company has failed, not able to run its profitable business. In some cases, we it is good for the company not to continue its business anymore. The ground is not failing of continuing. Ground is not business is not running profitable business, but we wish to diversify our business activities. We wish to change our business activities. In that case, it is better to discontinue our old business operation and start a new business operations. Uh, Starting a new business operation does not mean that old business profession is we are incurring losses in that. Maybe we are incurring profits, but we are not. We all decide to discontinue that business operation and start a new business venture. So it may be the most practical solutions for resolving issues that cannot be resolved through other means. The process can be lengthy and complicated, requiring the involvement of various stakeholders such as shareholders of the company, operators of the company, liquidators of the company. That is, the process involves very complicated by nature, very lengthy by nature, very cumbersome by nature. It involves so many stakeholders are involved in that particular when appeal has been filed by any of the members of the company, any shareholder of the company, so many persons are involved with the process of winding up of the company. Shareholders are there, creditors of the companies are there, liquidators are there, so they are responsible for the winding up of the company. And to avoid winding up by court, it is crucial for companies to maintain proper financial records, fulfill their obligations to creditors, and ensure compliance with the relevant laws and regulations of the company. So it is also essential to take timely measures to address issues that may arise, such as disputes among shareholders and management, financial difficulties or legal disputes. In that case, court may order for the funding of the company to address the particular issues of dispute among shareholders management. Financial difficulties, legal disputes are there. So we have to take timely measure to address these issues that arise time to time in the company for the smooth and efficient management of the company. It is important to seek professional guidance and advice to ensure that all legal requirements are properly met with and process is carried out smoothly and efficiently. So it is important to seek professional guidance and advice to ensure that all legal requirements are properly compiled with the company as required for the winding of the company, and that process is carried out in a smooth manner, in an efficient manner. So by this, I went up to today's class. I hope you all learned the concept of voluntary winding of by the order of the court, and winding by the order of the tribunal. Uh, so by this, I went up to today's class. Thank you all.